A very warm welcome to all. Today, I, Ria Khanna, a legal intern at Lexis and Company, am here to explain my topic restriction on women's entry to places of religious worship. Menstruation is one of the most basic human psychological process related to the propagation of our species. Generally, it has many taboos associated across the globe and different societies treat it differently. Some consider it a positive process and others as a negative one. It is a process that affirms the fertility of women, but is seen as the opposite. From ancient times, it is considered as a curse on women, attaching stigmas to them. Seen from a scientific perspective, women needs to reproduce. In the status quo, all of this has reduced as we have moved forward with generations. But looking at it in the earlier times, it was a big problem for women. The days of menstruation were difficult to sustain with all the taints about it, such as not sleeping in the house, entering the kitchen, or place of worship. Well, the first two have been overcome through science and has removed the tag of impure from it. The third one is still prevalent in the present time. Ban on entry of women in places of worship. Worship of the Almighty, which is practiced by every living being, has a notion attached to it in the Indian culture. As believed in the past and continues, menstruating women are not allowed inside the holy places of the country. The acceptance of the fact of the impure body at the time of the month is what restricts women from entering a holy place. The cultural belief of impurity associated with it is the main reason in our country. There are many famous places which are prey to the situation. To name them, Sabrimala Temple in Kerala, Lord Kartike Temple in Pushkar, Haji Ali Dargah in Mumbai, and many more. Let us understand the opposing view to this. The people who do not support the entry of women in temples argue that we should not overstep the traditional boundaries. Rituals and traditions are ancient gifts, and we should not adjust them according to our comfort. They support their argument by calling the whole process of menstruation degraded. It is also believed in some remote areas that women should not touch food as the food will become impure, and so will the men if they come in contact with the bleeding women. Let us understand the supporting view. Those who support the entry of women provide a logical argument, which is that there should be no intermediary between God and devotees. God is above all gunas and emotions, and hence there should be no dispute regarding the ban on entry of women. The four Vedas never taught that a woman's body is impure during menstruation. Essential religious functions under Article 25 and Article 26 in the Constitution of India. This test was coined by the Supreme Court way back in the year 1954 in the case of the Commissioner Hindu Religious Endowments Madras versus Sri Lakshmidhar Tirtha Swamier of Sri Shurur Mutt. The court in this case mentioned for the first time that what constitutes an essential part of a religion will be ascertained with reference to the tenets and documents of that religion itself. This doctrine gives birth to an unstable system that gives judges the discretion to decide each invocation of Article 25 on its own merits, depending on which religion the petitioner belongs to. Even an elementary reading of this doctrine will immediately expose how flawed it is and that it is blatantly violative of Article 14. The Supreme Court held that sometimes religious there are practices, even secular ones, usually considered as part of the religion, that might actually be superstitious and not essential to the religion, and hence are excluded from the protection of the Constitution. Besides the fact that what is religion to one might be superstitious to another, it is not for the court to grant or disinherit from any individual or group the status of separate religious domination. Any individual or group of individuals must be equally free to follow their traditions or rituals as long as the same are not barred by the restrictions given in Article 25, namely public order, morality, health, and the other articles of Part 3. Now, this is all for this particular video. In the next video, we will understand the famous landmark cases, including Indian Young Lawyers Association versus State of Kerala, All India Record 2018, where we'll understand the opinion of Chief Justice Deepak Mishra, Justice Nariman, Justice Chandrachud, and Justice Indu Malhotra's dissenting opinion on this issue. Another case that we will understand is Dr. Noor Jahan Safia Niaz and one another versus State of Maharashtra and others, All India Record 2016. And then we shall conclude it with the concluding opinion. Thank you.